If you were hit by a driver who does not have insurance in Alabama, you might be wondering, am I going to be stuck paying for this myself? It's one of the most stressful situations after a car accident. You're dealing with medical bills, car repairs, and now you find out that the other driver doesn't even have insurance. Let's walk through what actually happens and what your options may be. In Alabama, drivers are required to carry minimum insurance. $25,000 for bodily injury per person, $50,000 per occurrence, which is your accident, and $25,000 for property damage. Unfortunately, not everyone follows the law, and even if they do, those minimum limits may not be enough for serious injuries. If the other driver does not have insurance or has minimum insurance, your biggest protection is under your own insurance, also referred to as underinsured or uninsured motorist coverage. And this coverage exists specifically in situations where the at-fault driver did not have insurance or not enough insurance. It may pay for medical bills, lost wages, pain and suffering, or other accident-related damages, up to your policy limits. In simple terms, your own insurance company steps into the role of the at-fault driver's insurer. Now, here's something important. Even though this is your own insurance policy, the insurance company still evaluates the claim very carefully. They may question the severity of your injuries or dispute certain medical treatment, ask for recorded statements, or suggest partial fault. And that's especially important in Alabama because of contributory negligence. So just because it's your own insurance company, don't expect any favors. They will act like any other insurance company when evaluating your claim, and you still have to be very careful. In Alabama, even if you are the slightest percent, 1% at fault, you may recover nothing. That rule applies even under uninsured or underinsured motorist claims. So fault does still matter even if you're applying under your own insurance claim. And that is why being careful with statements and documentation is very important. So can you sue the underinsured or uninsured driver? Yes, you can definitely sue the underinsured or uninsured driver personally, but here is the practical reality. Many of these drivers do not have significant assets. And even if you win a lawsuit, collecting that money, that's difficult. That's why the most important thing to protect yourself that you can do is making sure that you have underinsured or uninsured motorist coverage on your own policy. So what if the uninsured driver was engaging in reckless conduct or was driving under the influence of alcohol or drugs or engaging in road rage? This is where things can change significantly. If the uninsured driver was driving under the influence of alcohol or drugs, or recklessly operating the vehicle, or engaging in road rage or street racing, that conduct would rise to the level of wantonness in Alabama. Wantonness is more than negligence. It shows a reckless disregard for the safety of others. And here's why that matters. Anytime the at-fault driver engages in wanton behavior, the value of the case goes up. If the at-fault driver had insurance coverage, the value on that claim would go up. But if the at-fault driver does not have coverage or not enough coverage, when you're applying under your own insurance, the value goes up. The value goes up because the at-fault driver showed a reckless disregard for the safety of others. So what reduces the value of an uninsured motorist claim? Several things can reduce the value of your uninsured motorist claim, such as delaying medical treatment, gaps in care, inconsistent statements, social media posts about the accident, recorded statements without preparation, and evidence suggesting partial fault. Because you're dealing with your own insurance company, people have their guards down. They think the process would be simple, but that's not the case. An insurance company is always looking out for themselves and not anyone else. So, should you speak with a lawyer? You may not need to speak to a lawyer in every uninsured driver case, but you should consider speaking with one if you have ongoing treatment, fault is being disputed, the offer feels low, the driver was reckless or impaired, or you're unsure about your coverage. Most consultations with a personal injury attorney are free. There is no downside to not reaching out. So it's important to note that just because the at-fault driver did not have insurance, that you may still very much have a case to pursue. So when dealing with your own insurance company in these scenarios, determination of fault matters. The coverage limits matter. And the reckless conduct of the at-fault driver can significantly impact the value of your case. Before accepting a settlement or assuming you have no options, get clarity. If you found this video helpful, check out our other videos, which are very informational. Videos on what to do after a car accident, what to do if you were partially at fault, or how do you evaluate the value of your case. Don't forget to subscribe, and thank you for watching.